Boom. It's been a day. Mondays, huh? Mondays. yeah, we're we're just gonna try whatever this is. It's a pink lemonade. Um yeah. So, let's talk about before we get into sort of the meat of things. I've been trying to get my hot sauce sold since forever, because yeah, I've got a whole bunch of hot sauce that I want to get moving, and I just don't know how to do it. Trying to figure all that out, and it is proving to be a major annoyance. Major annoyance, because I finally got a Shopify store set up, and then the first thing that happened is they went ahead and canceled it. They terminated my account, and I don't know why. I never did get an answer as to why they terminated my account. Yes, I know Emily uses Shopify. I tried using Shopify and they terminated my account. I don't know how to get in touch with Emily to, raise that with her or anything anymore. But yeah, what is it? Did I use Emily's promo code? No. But I did manage to get them to reinstate it. They canceled my free trial, but they did reinstate it after I sent in a thing. So I've got a store set up, and I don't know if it works yet because I haven't been able to put in a test order, because for some reason, when I put in my getting like, yeah, it's annoying. It's when I don't know what's going on, but it shows everything as out of stock. Now it's saying, hey, you could fix this by turning on a feature. There's a feature to I'm trying to do two things at once and I'm just tired. There's a feature to basically allow for like stock tracking. And the thing is I only have a certain number of these actual products, right? I just don't have other I just don't have any other products. So like if I sell out of them, then I just don't have any more hot sauce to sell. So the problem is that if I end up with my webpage live and it's, and I use the fix they want to go with, which is sell after I'm out of stock, then I could sell like 500 of them and I wouldn't actually have the sauces to sell, which would not really make friends with my community. And the thing is like I can get more hot sauce. The problem is that getting more hot sauce is going to be it's going to be like 4 months before I get that. So I'd be sitting on a whole pile of money and a whole pile of not able to ship anything. And I kind of feel like that would result in a very bad customer experience. And I don't want that. So I'm trying to get this figured out. I'm trying to do it kind of live and on the fly. I think I may have solved the problem. We'll have to see here. I am, I'm trying to juggle all of this now just to see, can I get my hot sauces going live? Now, the other thing about the hot sauces is here is how I plan to here's how I plan to do this, which is that I'm going to I'm going to throw the page live once I've confirmed that it actually works properly. And then, but the price initially is going to be stupid. And so what that means is it means don't actually don't place an order yet. And the reason why is because the initial order will be or the initial thing will be an opening for people who are sort of on the like members of various of whatever, right? And so what I'm going to be doing is I'm going to be opening sort of a 2-week period where there's going to be an open pre-order, and the pre-order is going to be so the pre-order is going to be essentially that if you're on there, you'll get a code for 75% off, which will take the price down to reasonable. But I don't want to have people buying it before I do that, because then they'll end up paying an insane amount. I am still not able. So I'm still not able to get this to properly process an order. What the hell? I'm trying to run an order through right now on Shopify, and it's just not working. I'm just trying to do it. I'd share the screen of me trying to do it, but I can't, because then you would see my credit card information, and that would not be good. Yeah, so I don't know how to fix this here. Yeah, I put in my shipping address and it says enter shipping address. Why does it say enter shipping address after I've already put in my shipping address? Okay. Yeah, I don't think what is it? I don't think Emily's going to be here. She's in New York, so and I don't really have a good way to hassle her to be like, come fix this. Okay, so yeah, that is the current holdup. Is I need to figure out that this is actually working before I can do anything there. And yeah, it's not working for me right now. I just don't know how to solve this. Okay. Somebody's saying I have to put in the address the correct way. I don't have a correct way to do it. I don't have a correct way to do it. Yeah. Guys, I'm not able to get Emily to help on this. It's just not a viable solution. So, yeah. And yes, right now this is just Canada only. I don't have a so I don't have a way to send these to the States. So yeah. All right. All right. So let us see what we can do here. All right. So we've got a few things to cover, and I think we're going to start with the big one first. The big one is Alec Baldwin. Alec Baldwin. So let us go to that. Somebody said, what did I think of C60's first reading in the House of Commons? I didn't watch it. So Bill C60, which one is that one? I'm not sure on which one we're talking about there. So is C60 grants the sum of $20 billion for Okay, so it's a funding bill. All right. Well, that's not going to be super exciting. All right. So we're going to look at Baldwin first, and then we're going to move on to other things. Baldwin is going to be our start. The problem isn't Shopify for selling to Canada or selling to the United States. The problem for selling to the United States is that in order to export my hot sauce to the United States, I need an FDA registration number for the kitchen where it was made. The kitchen where it was made does not have an FDA registration number. They're working on it, but they don't have one yet. If I ship them to the United States, I am committing a United States offense, and I don't want to do that because I need to be able to travel to the US. So I am following the laws, right? You need to have an FDA registration. Here, let's talk a little bit about my hot sauce and what is required, because all of this is you've got legal things. So here is one of the two hot sauces. There are various things that are required to be on this. There's been a whole bunch of legal compliance that went into this label. The first thing is these nutrition facts are required by Canadian law, and they have to be in a specified format with a font of at least a certain size. And so, yeah, the label is "Burn Your Regrets." And so that I had to. This was a pain in the butt. The next thing that they have is at the bottom. It says hot sauce / sauce piquante. That's also required by law, that I'd had to say hot sauce on it. Has to say what it is. You know, like you can't figure that out. It also has to say that it's 5 fluid ounces / 150 milliliters, because we're in Canada and it's got to have something in metric. So all of this stuff has got to be done. I can't screw around with it. If my kitchen, so what I'm hoping is that this initial thing sells out, but I don't know. And if it sells out, then I will make another batch. And the other batch I'm hoping will be will have an FDA registration, and everything will be good. The nutrition information is bilingual. The other information, the other random stuff, is English only. I can read you the other information. It's different from the two different bottles. But this is the slightly hotter of the two. The text on it reads, "If you can't solve your problems with fire, you're probably not using enough fire. This sauce is designed to be enough fire to solve most food-related problems. Overuse of this sauce may cause regret. 100% vegan, only cruel to humans. Gluten-free, made in Canada for Runkle of the Bailey Limited, Edmonton, Alberta." So, yeah. That's the flavor text on that one. So, yeah, I forget what all the text says on the other one. But yeah, they're ready to go. They're ready to get sent out as soon as I can figure out how to get them sent out and so forth. So yeah, I'm having all manner of trouble with this, and yeah. All right, let's have a look at the latest. Let's have a look at the latest problems that Kari Morrissey is having, because Alec Baldwin's counsel has some opinions, and you know what? I'm kind of here for it at this point. So let's have a look here. Table of contents, we don't care about. We're going to read the whole thing. Table of authorities, we don't care about. We're going to read the whole thing. Introduction. Introduction. The state waited until hours before the deadline to file a motion for reconsideration that exceeded the court's page limits by 42 pages. When the state's defective motion was rejected, it waited a week to file an amended motion. I don't know why they put amended motion in scare quotes, because it actually was amended. They put it down to 10 pages. So it was amended, right? It was amended. While at the same time requesting leave to file a third version of the motion. Well, yes, they are asking to be able to file a third version because they're asking for more pages. To this day, the state still hasn't filed a compliant motion. Wait, the amended motion, the 10-page motion, was compliant, right? Wasn't 10 pages compliant? I thought that was actually compliant. So the state's motions should thereby be stricken, or therefore be stricken as non-compliant and untimely. I see people saying it was 11. The cover page doesn't count. Neither does the table of contents. Neither does the other stuff. So yeah, I think it was okay, but I'm not certain. Now you guys have me questioning things again. People are saying count again. Okay, we'll count again. Okay, we'll count. So nope, that's the 32-page one. Oh wait, that's 32 pages with exhibits. Okay. So we don't read the exhibits. We have 11 pages. But what doesn't count? The conclusion and the header don't count. I think she's technically under, but it is debatable. It might be that she's this much over. So, because the conclusion doesn't count, and the header isn't supposed to count. I think she's technically okay. Technically. Anyway, we don't care that much. They say the state's motions should therefore be stricken as non-compliant and untimely. Now, you might be saying, oh, well, like, who cares if they're non-compliant or untimely? And this is why being a lawyer sucks. This is why being a lawyer really, really sucks. Because everything, like, once you become a lawyer, the rest of your life involves dealing with deadlines that sometimes can be insanely bad. And what I mean by that is, like, let's say you've got a client who wants to sue their neighbor for $100,000 for whatever, right? They're suing their neighbor for $100,000 based on, I don't know, the neighbor dumped oil on their property or something, right? Now, you're going, okay, $100,000 lawsuit. Often you've got a time limit to file of, say, 2 years. Here in Alberta, your time limit would be 2 years. And what that means is that on your last day, you still have a good lawsuit, right? 2 years exactly, you've got a good lawsuit. 2 years plus one single solitary day means that lawsuit is dead. Now, you might be saying, okay, whatever. But here's the thing. If I hire a lawyer like 1 year into my lawsuit's valid time, right? So I hire Bob, and Bobson, attorneys at law. And I do this a year after the injury that I've suffered. Well, they have a year to get around to filing it. And if they don't, if they forget, if they miss that deadline, then I no longer have a good claim against the original person I'm suing. But I've got a new claim. I've got a new valid lawsuit. That new lawsuit is against the lawyers, because now I can sue the lawyers for the value of my lawsuit. And I can say I had a good lawsuit, but you guys malpracticed my lawsuit, and now I get to sue you. And so as a lawyer, you end up having a calendar full of deadlines that basically say, if you miss this, your life is going to suck. Yep. And those deadlines can be a real big deal. So as much as to the ordinary person, it feels like, oh, whatever, I was late. Right? We're kind of used to being late. We're like, oh yeah, the bill's got to be paid by the 30th, but if I get it in on the 2nd of the next month, they might ding me for a late fee or whatever, but I'm still going to be okay. Law doesn't work like that. Law is like absolutely infirm and unfriendly a lot of the time. So what they very well might say is, listen, you missed your deadlines. You don't get to file anything. It is up to the court to decide if they're going to allow this to be filed at all or just dismiss it, or whether they're going to entertain it. So the first argument they're making, and this is a good argument, this isn't just throwaway bullshit, is throw this out because you missed it, right? You missed your deadline. But they say, alternatively, the motion should be denied on the merits. If you decide to hear this, well, then throw it out because it's garbage, right? Throw it out because it's trash. So the court provided a detailed summary of the state's egregious misconduct and a thorough analysis of the relevant factors under the case law. Based on its comprehensive analysis, the court properly exercised its inherent power and broad discretionary authority by dismissing the case with prejudice. No basis exists to reconsider the court's decision. But here comes Kari Morrissey. I hope that this is mockery for the use of comes now. I hope that this is use of mockery. But here comes Kari Morrissey after she repeatedly violated the state's disclosure obligations, buried evidence, lied about it at trial, and then lied about her reasons for lying about it. I love that. Lied about it at trial and then lied about her reasons for lying about it is hilarious. Hilarious. Morrissey has the audacity. That feels like a line from somebody I know. The audacity to ask the court to order Baldwin to provide a description and all documents related to when and how they learned of evidence that the state suppressed. It is difficult to imagine a more backwards or conceited attempt to blame the victim of the state's own willful and deliberate misconduct. Not only has the state failed to present any new information to warrant reconsideration, but the new information that has emerged since trial only underscores the strength and necessity of the court's judgment. And by the way, here is where they come in, dropping an absolute bomb. Absolute fucking bomb. You've seen the Matrix, like the first Matrix, when they walk in and they go up the elevator and they leave the bomb behind. That is exactly what we're looking at here, right? Because they dropped an absolute bomb here. Specifically, an affidavit by Special Prosecutor Erlinda Johnson. And this is the point when reading this, you should be going, oh, shit. Oh, shit. An affidavit by Special Prosecutor Erlinda Johnson, who was formerly Kari Morrissey's co-counsel. I'm just going to say this Christmas, I don't think Kari Morrissey and Erlinda Johnson are going to be trading Christmas cards. Holy shit. Erlinda Johnson walked into the law offices of the opposing law firm and swore an affidavit. Yeah. Yeah. That is exciting. That is insane. So, who, contrary to Morrissey's lies, resigned because of the state's misconduct, demonstrates that Morrissey continues to distort the truth. Now, I'm just gonna say, if I was Kari Morrissey, I would have dropped this. I would have dropped this a while ago because I feel like how do I put this? I feel like Kari Morrissey just can't let go of this case, even though the case is now like a bus that is driving off into the distance. And she is just hanging onto the bumper as it drags her over concrete and broken glass and like syringes. She is... This is the kind of case that normally I would expect the prosecution to drop straight up so fast just to avoid the embarrassment and the hurt that they are bringing onto themselves. This is one of those things of like Kari Morrissey is slamming her genitals in a car door and she just doesn't know how to stop. And the thing is you stop, right? You got to stop. It's like, what? Every time I try this, it gets worse. Stop, right? She's like, it's like she's holding a drill to the side of her head. And she's just like, I got to keep going until it stops hurting. It's like, no, stop now. Stop now. So, yeah. See Exhibit A, affidavit of Erlinda Johnson. We are definitely going to go over the affidavit of Erlinda Johnson. The court should ensure the integrity of the judicial system and the efficient administration of justice by striking and denying the state's motions. Argument. So now we're on to argument. 1. The court should strike the state's defective motion. The state's motion cannot exceed 10 pages without leave of the court, and the motion was required to be filed within 30 days after entry of judgment. Here, the state waited until hours before the deadline of August 30th to file a motion to reconsider dismissal with prejudice. At 52 pages, however, the motion exceeded the court's page limits by 42 pages. The state knew well in advance of August 30th that it planned to file a massively overlength motion, yet it inexplicably waited until the day of filing to request an extension. On September 3rd, 2024, the court denied the state's motion for leave. Now, I just want to note that page limits are also a big deal, and deadlines are a big deal, and so here's the thing. Like, let's say I have to file something with the Court of Appeal, right? I've got to go something with the Court of Appeal. And my deadline is, I don't know, October 30th, right? When am I filing this? I'm filing it probably like October 20th. Why am I filing it so early? Well, because if you file it on the day of, what ends up happening is you go in and you submit it for filing. And they say, We're rejecting this because the pages, the margins are just a little bit too big, or you use the wrong font, or all of those things, right? And the thing is you might not actually get the rejection back the same day. Like, I file it on October 20th, and then October 22nd, I get a thing back saying, rejected, you used the wrong font. And so then I have to resubmit, right? And or use the wrong color for your cover page. You used an off white instead of a buff cover page, so we're rejecting it. You've got to resubmit it. And the thing is if that rejection causes you to bounce over your deadline, if that rejection bounces you over the deadline, your appeal is dead, and you may have to actually apply to the Court of Appeal to be like, I got to get this revived. I got to get this revived again. So, yeah. So, on September 5th, the state filed a motion to reconsider the motion to exceed page limits that seeks to file a 22-page motion. At the same time, nearly a week after the deadline to seek reconsideration, the state filed an amended motion to reconsider dismissal of prejudice. The amended motion is 11 pages long, also beyond the page limit. I don't know that it actually is 11 pages. I don't know that it actually counts as 11 pages, but they're saying it's 11 pages. We'll see. We'll see. This court has not ruled on these motions. After the court denied leave to file the state's non-compliant motion, the state waited an entire week to file its amended motion. I suspect that the entire week wasn't like Kari Morrissey sitting there like, I'm gonna learn to juggle. Like, they denied my motion, so now it's time to, now I'm gonna learn to juggle, and I'm definitely not good at juggling. I think she was probably spending that week trying to amend it down and to get to within the page limits, right? I think that's what she was doing. So yeah. They note the court should strike the motions as non-compliant, i.e. too many pages, and untimely. You missed your deadline, you suck, you're screwed, it's over, you lose. So, yeah. All right. And the next thing is the state cannot circumvent the deadline by filing a grossly non-compliant motion on the due date and then filing a second, still non-compliant motion nearly a week later. Now, I don't think that I don't think she filed the 52-page thing as a way to get like a bonus extension, right? Sometimes you'll see lawyers do that where they'll try to file something and then they'll be like, oh, and now I want to amend it. And it's clear that the first thing was filed only to like catch the deadline. I don't think that's what's happening here. I think it's just like, I think she just like spent the entire time writing a 52-page monstrosity. And then when the judge is like, no, I'm not reading this, she's like, oh, now I got to edit it down. So finally, the court should award Baldwin's attorney's fees for having to respond to the state's defective motion and as a sanction against Morrissey for her continued abuse of the judicial process. So here is where they have run out of patience entirely. And, they have said not only should Kari Morrissey be told to fuck off, right? But Kari Morrissey should be told to fuck off with money. You need to attach a penalty to this. And you know what? I think it's appropriate. I think it's justified. I think it's called for. So I think they might get it. I think they might get the. I think that the judge may say, "I'm dismissing this, and I'm awarding." I don't think she's going to award actual attorney fees, but I think she may come back and say, "I'm awarding $5,000 as a fuck you, Kari Morrissey, as a knock it the hell off, Kari Morrissey." The state's motion for reconsideration should be denied. While a motion for reconsideration is appropriate where the court has misapprehended the facts, a party's position, or the controlling law, it is not an appropriate vehicle to revisit issues already addressed or advance arguments that could have been raised in prior briefing, as the state attempts to do here. I.e., it's not a do-over. It is not a second chance. A motion for reconsideration is, "Judge, you screwed up." But it's not, "Judge, I thought of something new. I have a new argument." Right? You don't get to bring your shower thoughts to the court. And we've all had that moment, right? We've all had that moment where you get into an argument and you do your best. And if you're a lawyer, this is what happens all the time. And then as soon as you walk out, you get in the shower later, you're like, "Oh, that's the argument I should have made." Being a lawyer is all about those moments. It is all about the moments that you are, like, every single trial, every single hearing that I have had that's been a contested hearing in any way, I walk out and I immediately start thinking of what I should have done. Like, I should have done this in that cross-examination, or I should have made this argument in my closing, right? And this applies even when you win. Some of you have watched my Supreme Court appearance, and some of you have said, "Hey, you did a pretty good job, Runkle." And I guess the Supreme Court said, "Hey, you did a pretty good job, Runkle," because I won. It took months, literally months, for me to stop thinking of things I should have argued and things I should have said at the Supreme Court, even though I won. So you might think, "Oh, but the thing is if I had lost, I wouldn't be able to go back to the court and be like, I just thought of this idea. I just thought of this argument. I just thought of this. You got to rehear me." They're like, "No, no." Tough, right? So this is the thing. And I think that, like, I made this point before, I'll make it again. Kari Morrissey ought to have asked the court for more time. If she couldn't have responded to it during that moment, she should have asked for more time. But she didn't. She went ahead right away because she thought for sure that the court was going to punt it. And she was wrong. She was wrong. The state does not even attempt to present new evidence or information in support of its motion, and even if it did, the court may properly refuse to consider it. And this is the thing, is Kari Morrissey doesn't say, "Hey, I have new evidence." Kari Morrissey says, "Hey, you should inquire into the defense as to whether they have new evidence," right? I said that is the argument that is the best argument Kari Morrissey has. I don't think it's going to fly. But it is her best argument. Nor does the state cite any new or controlling authority to support its attacks on the court's rulings. Instead, new information to emerge since trial underscores the strength and necessity of the court's decision. See Exhibit A, that's Erlinda Johnson's. The state's motion for reconsideration should be denied. I actually think that they don't need to write as much as they did. They have 16 pages here, but of which 10 pages is the so it is a 10-page filing, but they have and I don't think that they need all of this. I don't think they need all of this at all, but they file it. So next, the state's misconduct was egregious. Now, the thing is, the court already knows this, and that's why the court ruled, but they get to dunk on Kari Morrissey a little bit harder. So the state withheld information virtually from the beginning of this case all the way through trial. It culpably made late disclosures of multiple expert reports from related to the firearm and thousands of files, including over 150,000 pages of documents and dozens of gigabytes worth of data. Now, here's the problem with measuring data. I hate. This is a minor peeve now. This is a minor peeve. The minor peeve is measuring disclosure or anything like that in gigabytes of data is not super useful. And why do I say that? Well, because I have seen a gigabyte of data turn out to be a video that was 10 minutes long. And you might be saying, Runkle, how was a 10-minute video a gig of data? And I can tell you, one word explains it. One word. Can anybody in chat guess how this giant 10-minute video file came to exist? One word. Anybody? There's one word I'm thinking about, and I'm wondering if anyone can get it. It's not uncompressed. It's not raw. That's not 4K that I'm thinking. The word that I'm thinking is casino. Casino. And the reason why I'm thinking casino is because casinos have insane levels of video. To put it into perspective, in this 10-minute video, it shows my client engaging in the misconduct from about 100 feet away in this video, right? Way far away on this camera. And I was able to zoom in on that video to read the label of his pants. I was able to tell him the brand of pants he was wearing from about 100 feet away. If you pull out your credit card in a casino, they have your credit card information. If you anything in that, it looked like a photograph zoomed right in, right? So casino video is insanely high res, just ridiculously high res. And I see people saying 4K or more, way more. What was the resolution? I have no idea, but it was just insane. All right. So, and no, it wasn't that the pants brand was illegal. It was just, I was amazed at how good the video was. And, yeah, it ended that file. I can tell you that, because the client was all like, oh, well, nobody saw anything. And, I was able to show the client the video, and he was like, oh, yeah, that is definitely me. And I'm like, yep, that is definitely you. So dozens of gigabytes doesn't necessarily mean much. You can watch a 10-minute video in 10 minutes. But, yeah. So dozens of gigabytes worth of data, such as lapel videos and audio recordings of interviews with key witnesses. So see also expedited motion for relief for states' Brady and state law disclosure violations related to the firearm, and expedited motion for relief related to non-firearm discovery. It waited until the eve of trial to disclose over 1,100 pages of discoverable documents that Kari Morrissey had previously refused to provide. So the list goes on, and they're going to rehash all their greatest hits here. In short, the state continually made late disclosures to defendant throughout pretrial litigation, and even in the days immediately preceding the jury trial, beginning on July 9th, 2024. Yet the state repeatedly certified that it had met its disclosure obligations. So, state's response to Baldwin's expedited motion for relief, etc., they say, the state conducted a complete audit of its disclosure files as soon as it was aware that potential problems existed, and has cured any discovery disclosure issues. These representations and certifications were false. Vez, no need to apologize for being on replay, crew. All right. The state's pattern of misconduct and misrepresentations continued at trial. So on July 11th, crime scene tech Popple falsely testified that she had logged all of the evidence she collected in this case, and that by logging it, she also made it available for the defense so that the defense would have visibility into what, in fact, she collected. In fact, despite Baldwin's specific request to see the ballistics evidence, all rounds, casings, deconstructed rounds, etc., crime scene tech Popple, along with other SFSO agents and Special Prosecutor Morrissey, intentionally and deliberately withheld this evidence by placing it and other related evidence under a non-Rust investigation case number. In an attempt to explain why the Teskey supplied ammunition was buried under a different case number, crime scene tech Popple testified that the ammunition did not match the live ammunition found on the set of Rust, but this too was false. Now, here's the thing. I don't know why there would have been any reason to put it under a different case number. Just no reason whatsoever. Because if it's not Rust related, then what the fuck is it about, right? What is it for? Why would you even take this ammunition if it wasn't Rust related? Right? Like, do you think there's some additional crime that was going on? I don't understand. By the time Special Prosecutor Morrissey took the stand as a witness in her own prosecution, the state had already admitted to burying the Teskey supplied ammunition and lying about it in front of the jury. Throughout Morrissey's testimony, the lies continued. Now, here's the thing. And I see you. I'll do it in a moment here. What is it? If the court finally gives a reason that says Kari Morrissey explicitly lied, like then she's possibly facing a serious career consequences, because a lawyer who is found to have perjured herself, if that's what the court ultimately decides to find here, that is potentially disbarable. She is at this point running the risk of getting disbarred or charged just trying to chase Alec Baldwin. And I gotta say, Alec Baldwin is a giant sack of jerk. And not like chicken. But don't risk your career for Baldwin. He's just not worth it, right? He's just not. No. This is why I tell lawyers all the time that if you are too invested in a file, get off that file, right? Get off that file. I have fired clients before because I really hated them, and it happened. I was just in an ethical, I was in a spot where it's like, ethically, I can't continue to represent you because I really just hate you. And you need somebody who doesn't hate you. But I've also fired a client because I liked them too much. And I was like, listen, I don't think that I am the lawyer you need going forward, because I don't think I can critically assess your case. I think I've gotten too close to this case and I need to step away from it. I was like, I think I'm too on board with your thing, and I don't know that I'm seeing the weaknesses in the case anymore. Someone else is going to take it. Someone else is going to take it. If you're wondering who did I fire because I thought they were too much of a jerk, that I hated them too much, it was a child sex offender who really, really liked to brag about it and wanted me to agree with him that what he had done was awesome. And I got to a point where I was just like, I hope this guy gets hit by a bus. And at that point, I was like, he needs a new lawyer, right? He needs a new lawyer. The liking too much was a self-defense case where I was like, yeah, I thought that was I was like, I don't know that I'm looking at this properly. So, how can anyone brag like that? Well, some of them are very twisted, messed up people, right? And some of them have this notion of basically this notion that what they're doing is normal. And yeah. All right. For example, Morrissey's statement that she had never seen the Teskey supplied ammunition and didn't realize it was under the same case number was contradicted by Corporal Hancock, who testified that the SFSO agent, Special Prosecutor Morrissey, decided to separately file this evidence apart from the evidence of the Rust investigation. Now, I actually think that Corporal Hancock is not necessarily the most believable either, right? I don't think that Corporal Hancock is necessarily. I didn't find her super truthful, right? So yeah. It also defies belief that Morrissey wouldn't have asked what type of ammunition Teskey delivered. She might have asked, but she might not have gone to look at it, right? She might not have actually physically examined it herself. She might have asked crime scene tech Popple to do that, right? The intentional misconduct and fabrications that emerged at trial are consistent with Morrissey's pattern of withholding evidence and lying about it from virtually the moment she took over this case. Now, I just want to say, from the beginning of this case, Nikas and Spiro have clearly hated Morrissey, and Morrissey has hated them too. And they've been winding each other up. They've been throwing barbs at each other. They've been throwing shit at each other. And you know what? Nikas and Spiro get to do the last word dance on this one. So, I mean, I guess if I ever see them in person, I will buy them a drink, and the drink I buy them will be a last word. And if you've never had a last word, they're actually a pretty tasty drink. So yeah. Morrissey's misconduct has continued even after dismissal. For example, contrary to Morrissey's latest claim that she never refused to provide unredacted copies of documents that Baldwin had obtained through an IPRA request, Baldwin has learned that Morrissey told Special Prosecutor Johnson to ignore Baldwin's request and review the documents for discoverable material. Johnson refused to ignore Baldwin's request, citing her ethical obligations to ensure the proper discovery was disclosed, which ultimately led to the production of 1,100 pages of documents on the eve of trial. So Johnson also states that Morrissey's testimony about why Johnson resigned, i.e., that Johnson didn't agree with the decision to have a public hearing about the state's suppression of evidence, was another lie. Johnson withdrew because she learned of undisclosed evidence during trial and felt that her ethical obligations called for her to withdraw. So some people are asking, what is in a last word? Whoop. And here we go. Last word. A last word is 3/4 of an ounce gin, 3/4 of an ounce green chartreuse, which you will not find in your average bar, but I feel like you will probably find in the kind of bars where a lawyer like Nikas or Spiro hangs out. 3/4 of an ounce maraschino liqueur, 3/4 of an ounce of lime juice, and garnish with a cherry optional. It is a sour, sweet, lime kind of drink. They're delicious, but you won't often find them. A very similar drink to a last word is what do you call it? A paper plane. Paper plane is very similar to a last word and is also delicious. Paper planes are one of my favorite cocktails. If you encounter me in a bar and you're wondering what to get me, if you're in a Canadian bar where you can get a Caesar's a good choice. If you're in an American bar where you can't, then a paper plane is a pretty safe bet. If they have paper plane making stuff, which they don't always. I tend to, just as a random off topic, I really annoy some bartenders and some servers. And the reason why I annoy them is because I order all over a drink menu. So I'll go in and I'll order multiple different, I'll order different things off the drinks menu every time I order something. And so I'll often drink 5 different drinks in the course of a night, which a lot of bartenders don't much care for, because they're like, you should order the same thing, because most people order the same thing. They sit down and they have a beer they're drinking and they drink that beer all night, and that's it. And yeah, that's not me at all. So he says, as long as you tip well. I tip well. I've been known to, I went to a bar at one point, and what is it? I knew I was going to be drinking heavily. And so I just went to the bartender and I was like, here's $40 for my tip. That's my tips for the night. But I'm going to be too drunk to remember to keep tipping later. So there's my tips for the night. And I can tell you the service I got was astoundingly good. So yeah. All right. Yeah. Let's keep going here. That was another lie. Johnson withdrew because she learned of undisclosed evidence during trial and felt that her ethical obligations called for her to withdraw. So the case law supports dismissal. Given the government's misconduct, the court concluded that dismissal with prejudice is appropriate for several reasons. The court reached this conclusion by properly exercising its broad discretionary authority and conducting a thorough analysis of the relevant factors under the case law. There is no basis to reconsider the court's analysis. First, as the court recognized, the state violated Baldwin's rights under numerous rules, state and federal case law, and the court's February 26th scheduling order. Despite admitting that it may have suppressed the ammunition from defendant, the state argues that no Brady violation occurred because the evidence is not favorable to the defendant and is not material to his defense. That is wrong. That is wrong. As explained in Baldwin's motion to dismiss, to which the state declined to make a written response, proving the state's theory that Baldwin should have known of the risk of live ammunition being brought to set would require the state to establish a link between Baldwin and the source of the live ammunition. Now, I don't think that's true. I don't think that that is actually true. Because there's always a risk when you point a gun at somebody and pull the trigger, right? You shouldn't be pulling the trigger. I mean, I think that Morrissey's argument was going to be you shouldn't be pulling the trigger until and unless you're told, right? Until and unless you're told. Jill Higgins, who I got to meet when she was up here, and I said, you've got to try you've got to try a Caesar. Yeah, I may have caused problems there. All right. So this is Morrissey's argument, right? This is Morrissey's argument is that it doesn't matter if he knew specifically, but there is past risk. He knew about the incident on the filming of The Crow. He knew that there was risk. He knew that there was danger. And therefore, he knew that pulling the trigger while pointing it at a camera woman, pointing it at the cinematographer was dangerous, right? He should have known that. Should have been aware of that. But that was her argument, right? The flip side of this is that Spiro and Nikas, and through them Baldwin, are entitled to make their own argument, right? They're entitled to make their own argument as to what's going on here. And Morrissey basically had this notion that like her theory was the only theory that could be argued. And that's not the way the law works, right? Spiro and Nikas would have been entitled to argue a different way for the case to go down. So, yeah. The state aimed to prove this theory by pointing to evidence that the fatal round was brought to set by Gutierrez-Reed and arguing that Baldwin should have seen her relative youth, inexperience, and incompetence as a red flag. Now, I mean, everybody knows that like Gutierrez-Reed was a dumbass. And yes, one of the puppies had a speaking objection. I don't know what about. I'm just going to step in and talk about this one here. If you go to a bar and you want to ask what the bartender thinks is interesting, you need to make sure the bar isn't busy. And you also need to make sure that the bartender likes you. And the reason why is because if the bartender likes you and it's quiet, then you might get some unusual drink that is tasty and good. But if the bar is busy and they don't have time for your bullshit, or if the bartender doesn't like you, then you will have a different experience, which is that the bartender will get you something interesting that will discourage you from ordering that again. Specifically, they will get you the liquid version of Kari Morrissey's arguments and Kari Morrissey's motion. So if you ask the bartender for something interesting when they're slammed busy, you are probably getting like the they're gonna pour out that like cap, like the catch mat, into your drink, or they're going to be like, okay, one ouzo mixed with hot sauce, mixed with lime juice, mixed with cream. Here you go. It's like a cement mixer, but spicy and ouzo. Like, so don't make enemies of your bartender that way. All right. Notwithstanding the state's clear strategy, the state now falsely claims that it never intended to establish a link between Baldwin and the source of the live ammunition, and that Baldwin didn't need to know there were live rounds on the set for the state to prove its case against him. They could argue that that basically it would have been equally dangerous if there had been a blank accidentally loaded, right? So yeah. But that is not the legal standard for disclosing exculpatory evidence. The fact that the government may also have advanced other theories of guilt did not absolve it of the obligation to turn over evidence that exculpated Baldwin on one of its theories, which involved tying the source of the live ammunition to Gutierrez Reed and accusing Baldwin of recklessly relying on her as the armorer. Now, I don't know if they would actually make that argument, right? I don't know if they would actually argue that, but maybe. Moreover, by acknowledging that there is evidence that Baldwin's actions may not have been the only significant cause of Ms. Hutchins' death, the state effectively concedes that any evidence that attenuates Baldwin from the source of live ammunition is both material and favorable to Baldwin's defense. Okay, chat, I need to step away for just a second, and that is because I have just been told that there is a delivery on my porch. That is what the dogs were barking at, and that delivery on my porch is something specific based on where it came from. So, we are gonna roll something real quickly. I'm just going to roll, I don't know, we'll play this. Okay, so I really wanted to show you what's wrong with this, and YouTube won't let me do a live demo with guns, so this I have to pre-record. So this is the same make and model of revolver that we're talking about here. And so you can see we're just going to check once again. This is unloaded, but we're going to check that again. So we put it in half cock, we open it up, and I'll just let you guys see. Unloaded. Okay, so what she said, and I'm just going to lower the hammer again here. What she said is that you have to pull the trigger and the hammer back at the same time to half cock it, which is not at all how this works. If you want to put it into half cock, you just pull the hammer only, just the hammer. That's all you do. Let's watch that again. So, hammer, that's it. That puts it into half cock, and now we can open the loading gate, and we could load this if we wanted. So that's not how that works. Now, if we do this the way she said, pull hammer and this back the same distance, that's a bang, folks. Hammer. The reason why she has a negligent discharge when she's doing this is that she's actually doing it in the way you would do it if you intentionally wanted to have a negligent discharge. Now, I don't know if that's Sarah didn't learn or if Hannah taught her wrong, but that's dead wrong. And I mean that quite literally. That is something that could kill people. Okay, back to non-pre-recorded Runkle. Non-pre-recorded Runkle. Hey, folks. So Mrs. Runkle got it. I was worried that it was left on the porch because it was 1,000 rounds of ammunition. And I didn't want that sitting on my porch for some porch pirate to grab. So, yep, just like, oh, right. 1,000 rounds of ammo. Cool. That needs to not be on my porch. So, all right. Let's keep going here. Moreover, by acknowledging that there is evidence that Baldwin's actions may not have been the only significant cause of Ms. Hutchins' death, the state effectively concedes that any evidence that attenuates Baldwin from the source of the live ammunition is both material and favorable to Baldwin's defense. In addition, as the court observed, Baldwin could have used the suppressed ammunition as impeachment material against multiple witnesses and against SFSO's investigation generally. And this is the other thing. This is an excellent point. They could have said that all of the they could have said that that this indicates that their investigation sucked. And if they can establish that the investigation sucks, then that helps Baldwin, right? It really helps Baldwin. It really helps Baldwin's thing if these police officers suck at their job. Okay, cool. The argument that the rounds do not serve to impeach anyone other than crime scene tech Popple is both false. The evidence also impeaches Hancock, the lead detective, among several others, and also incredible, coming from a prosecutor whose own statements are impeached by that evidence. Oh, nice. Oh, nice. That is a little bit of shade. I love it. It is also irrelevant since the ammunition itself is not the only evidence that was suppressed. Nor do any of the state's arguments absolve Morrissey of her admitted failure to comply with the law, the repeated violation of which is sufficient to warrant dismissal even without a Brady violation. So, yeah. Second, although Brady does not require a showing of culpability, we don't need a showing of culpability, but we got one. The court properly found that the state was highly culpable for repeatedly failing to fulfill its discovery obligations during pretrial litigation of this case. The court further found that the suppression of the Teskey-supplied ammunition and related evidence constitutes willful and deliberate misconduct, and that Morrissey elicited false testimony from crime scene tech Popple in the presence of the jury. So, yeah. Sharon noting, I don't think you're allowed to sell products that are for human consumption without certain criteria being met. Yeah, I know. I've met the criteria. I'm allowed to sell this stuff. I've been through for the people who are worried that I'm breaking the law selling my hot sauce, I have done everything I can to make sure I am 100% within the law, including not selling to a bunch of people who really want my hot sauce. So, yeah. Yeah. So the state was highly culpable for repeatedly failing to fulfill its discovery obligation during pretrial litigation of this case. The court further found that the suppression of the Teskey-supplied ammunition and related evidence constitutes willful and deliberate misconduct, and that Morrissey elicited false testimony from crime scene tech Popple in the presence of the jury. As the court correctly noted, refusal to comply with discovery orders may rise to the level of dismissal where the state's conduct is especially culpable, such as where, as here, evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransigence. And I'll address this one here. Because Morrissey had zero chance of prevailing, did Baldwin's lawyers necessarily have to respond? I think they wanted to respond because the chance was not quite zero. And I think that also that they wanted to respond because they really, really hate Morrissey. And this is such a chance to dunk on Morrissey. I don't think that they would have passed this up. Honestly, this is one of those moments in your legal career where you're just like, oh, yeah. And the thing is, they're going to send Baldwin a bill for doing this, right? They're going to send Baldwin a bill. But they're going to enjoy it too, right? They're going to enjoy it too. What's the line? It's from Fight Club. I don't have a clip. I should have a clip. I should get this as a clip ready to go. The line from Fight Club is, "This isn't love, it's sport fucking." And that's what they're doing right now, right? That is what they're up to right now. So, yep. Yep. Yeah. All right. Third, the prejudice to Baldwin is clear. As the court correctly notes, if Baldwin had access to the Teskey supplied ammunition before the third day of the jury trial, he would have altered his approach to his preparation for trial and the trial itself. The state argues that Baldwin could not have been prejudiced if he was aware of the ammunition and its characteristics prior to trial. As an initial matter, the state's argument ignores the fact that the state withheld additional related evidence beyond the ammunition itself, including the supplemental report, the lapel video, and the fact that the ammunition had been logged under a different case number. Now, I just want to note what the defense is not saying. There's one critical thing the defense is not saying here. Are you catching the thing they're tiptoeing around as they're arguing here? The gap in it? Because sometimes you can learn as much from what isn't said as you can learn from what is said. And what isn't said here, they don't say that they didn't know about these bullets. They don't say that in this filing here. And I'm like, that's interesting. So this is where I would have dropped that. Maybe I missed it, but yeah, they just seem to be saying, yeah, we're just going to tiptoe around those particular tulips. So, what is it? They note, to the extent that the defense may elicit evidence about the Santa Fe County investigation, the FBI testing, the Hague's 3 reports, this evidence is relevant. Thus, the court properly found that the disclosure of the suppressed evidence during the course of trial has impeded the effective use of evidence in such a way that impacts the fundamental fairness of the proceedings. That said, I think that they did a good job of saying there's a bunch of stuff we didn't have that we didn't have the lapel video and we could have used that. So yeah. They note, for example, at any rate, the state cites zero authority for the argument that a defendant cannot show prejudice from the state's unilateral withholding of evidence unless the defendant had no inkling of the evidence's existence. Which again seems to suggest that they did know it exists, right? That they did know it. That, if I'm the judge, I might ask them to respond to that. I might ask them to just be like, clarify whether or not you knew. So the law holds otherwise. For example, the New Mexico Supreme Court has found prejudice where the state failed to disclose the defendant's own arrest report, noting the defendant might have altered his strategy if he'd known of the state's intent to use the report at trial. Okay, fair enough. They knew it existed. They didn't know the state considered it relevant. But here, the state didn't intend to use these bullets, right? So, and they quote another case that has defendants' arguments that this information would have affected his decisions regarding trial strategy are persuasive. Okay. The same logic applies here. The state cannot seriously argue that repeated violations of the rules do not cause prejudice when the whole point of the rules is to eliminate unwarranted prejudice. Baldwin was entitled to pursue the truth at trial, especially after he requested to see all rounds, casings, and deconstructed rounds in the state's possession, which plainly encompassed the evidence that Teskey delivered to the state, and yet the state deliberately withheld the evidence Baldwin had requested. So, put simply, Morrissey's argument amounts to the assertion that she was entitled to violate the U.S. Constitution, deliberately hide evidence, and lie to Your Honor and the jury because Baldwin learned that someone may have delivered evidence to the state. So, they're pretty much saying we knew. evidence that Morrissey concealed during the evidence inspection and represented didn't exist in her certifications. That's clearly not the law. Fourth, the court correctly found that no lesser sanction could cure the fundamental unfairness that the state's misconduct and its reverberations in trial had infused into the proceeding. So, as noted in Davidson, our Supreme Court does not attempt to limit the use of sanctions, including the sanction of dismissal with prejudice, when the state either breached some duty or intentionally deprived the defendant of evidence. So already the sanction that they imposed was the sanction of dismissal with prejudice. And Elfliggins makes a good point, but I'll put a caveat at it. Defense gets to hide the ball, prosecution does not. And this is true for the most part, although some places do have disclosure obligations on the defense. But typically, as the defense, in Canada, there's no disclosure obligations on the defense. So if I have a photograph, like let's say my client is accused of murdering Bob, who seems to be having a bad day. My client is accused of murdering Bob. Now I have a video. That actually shows Joe murdering Bob. Like, I got that on video. It might be a good idea for me to give that to the prosecution before trial, but I don't have to. I can sit on that right up until trial. I can wait until the last day of a 6-week trial where they have been doing their best to show that my client killed Bob. And then I'm like, oh yeah, here's Joe doing it. And you guys just wasted a ton of money, right? I could do that. Defense gets to hide the ball to a certain extent. But you can't hide the ball in representations to the court. And that is where they might get into some trouble here, is that the court might say, listen, the court might, and this is a slim possibility, the court might say, listen, I thought you didn't know about this evidence. And I thought you didn't know about this evidence, and that's why I ruled this way. And I wouldn't have ruled this way if I knew. And I mean, this is a fair point. I would need to have my client's instructions, right? I would need to have my client's instructions, but yeah. But the thing is if the defense, the judge could say, I wouldn't have given the dismissal with prejudice if I knew that you knew about it. The judge might also say, listen, I think you set this up. Because the other thing is that if the judge thinks that this was a ruse that was being played by the defense, then the judge may say, listen, you had the obligation to bring these complaints earlier and to bring this motion earlier rather than waiting and letting this play time bomb. So the judge might say, you've played malicious law, squirrel, trial's back on. I think the odds that the judge says trial is back on are like less than 5%. I don't think that the judge is going to fire up this trial again, right? I don't think that the judge is going to be like, oh yeah, totally time to get this going again. We're going to have ourselves a new trial. But if the trial, or if the judge was trying to do it, if that was something that the judge was considering, that would be the basis for it, right? Yeah, like checking a gun for bullets, the prosecution has an obligation to produce even when tested. Yep, and I agree that the prosecution screwed up. I just think that the judge might determine that the degree of prejudice, the degree of harm to the defense doesn't get to dismissal with prejudice if they already knew, right? That it was so she might say, I would have awarded a different remedy if they knew, right? That is the slim thing. Now, I just want to say that for Kari Morrissey to win at this point, or to, pull that off, is kind of like trying to throw a dart through like 12 hoops that are lined up. It's got to be just this perfect throw. So I don't think that's going to happen, right? I don't think that's going to happen, but there's a slim possibility. So, yeah. All right. In short, trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated. The state cannot seriously argue that the court's ruling is clearly untenable or not justified by reason, such that it exceeds the bounds of all reason or is arbitrary, fanciful, or unreasonable. And I agree, it's none of those things, right? So, yeah. Baldwin has not found a reported case involving a more egregious pattern of prosecutorial lies and abuse. As the court noted, dismissal is necessary to ensure the integrity of the judicial system and the efficient administration of justice. So, for the above reasons, the court should deny the state's amended motion, or in the alternative, strike the amended motion as untimely and award Baldwin's attorney's fees. So, now I should note, if they get attorney fees on this, they're not going to get attorney fees for the entirety of this matter, right? What they might get is attorney fees for this motion. And that's a good thing for Morrissey because the difference in cost. Now, the other thing is that the judge, if she's inclined to award fees, right? If the judge says, you know what, you're paying the attorney fees. Let's say they're $10,000, right? Which is probably low. It's probably more like 25 or up because they've got a bunch of other, but Baldwin doesn't care about the money. Baldwin has probably spent that much money on a night at the wine bar, right? And then if he was a Canton police officer, he'd drive home afterwards. But, this is probably the kind of money Baldwin might use to wipe his... Yeah. But he'd still really like to stick it to Morrissey. But the judge has options. If the judge says, you know what, I am awarding those fees, most likely she awards those fees payable by the state. New Mexico gets to pay those fees. Now, that still ends up like being a big embarrassment for Kari Morrissey, right? It still ends up being a problem on that, right? But if the judge really, really wants to say, fuck you, Kari Morrissey, she could order that is payable by Kari Morrissey personally. That almost never happens. I don't think it's likely to happen today. I don't think it's likely to happen on this. But it could. It's theoretically possible. And if she has to pay that personally, that'll hurt. Now, I'm going to assume as well that Kari Morrissey makes more money than I do. And part of that is because I make less money than I could because the areas of law I choose are areas that are mostly like helping the public and doing free work and stuff like that. I don't make as much money as many of my colleagues. I certainly don't make as much money as like the colleagues who went into big law. But like, I am not rolling in money. And it kind of sucks when you're like, I'm hoping to buy some land and I'm like, I don't know if I can ever afford that. But yeah, I assume she makes more money than I do. But it'll still hurt. If the court says she's got to pay 10 grand, it's still going to sting. I don't know a lot of lawyers who are in the position where like a 10 grand hit isn't going to hurt them. And Peyton, I make above minimum wage now, but I can tell you I have had years in my practice, multiple, when I am pretty sure I made below minimum wage. And I was still doing free work. And that was part of why I was making below minimum wage, is that a bunch of my work was free. But, if you do 3 trials and you get paid for none of them, then you're making below minimum wage. It is just a thing. All right. So, we're not done with this one yet. We're not going to swoop-de-swoop. Laura M says, does Mrs. Runkle get mad at you? I think Mrs. Runkle would have liked me to earn more money during those years. But Mrs. Runkle also has been tremendously supportive of the times when I want to do, when I want to be a sort of, crusader and so forth. So she puts up with that. Yeah, she knew who she married. Yep. She knew who she married. So that, she put up with me when I wasn't making money in law school. She put up with me when I wasn't, now my camera looks clear to me, but you're saying it's not in focus? Well, crap. I need to replace my camera. It sucks. Is that better or worse? I don't know. But yeah, Mrs. Runkle has, she's been patient for a lot of that stuff. Okay. So let's look at part of the exhibits, because the exhibits are 29 pages. 29 pages. We're not going to look at all 29 pages. We are going to look at Exhibit A. Exhibit A. Because Exhibit A is the bomb. And what I mean is Exhibit A is absolutely the thing that is going to cause huge problems for Kari Morrissey. Affidavit of Erlinda O. Johnson, Esquire. Now, I just got to say, in the U.S., they use Esquire a lot more than they do in Canada. Now, in Canada, the only lawyers who use Exhibit A, or sorry, not Exhibit A, Esquire, the only lawyers who tag themselves as Esquire are assholes. It is a sign in Canada. If you see somebody who, if they start saying like, name, Esquire, then that is, yeah, that is a jerk, right? That is an asshole. So don't do it. Who else have I seen Esquire? Every time I've seen Esquire, like sent to me in a letter or something, every time I see that, I check that person's credentials, because the other people who put down Esquire are non-lawyers who want to pretend to be lawyers. They put down Esquire. So Esquire is regional. In some places in the US, you put down Esquire for every lawyer, right? It's just like everything that is a thing you do. In some areas, not others. In Canada, we just don't do it. We just don't Esquire at all. So I saw a new lawyer who used Esquire and got like chewed out for like, you should not be doing this. So Claude Simeon, is Esquire not appropriate in a formal letter? I don't put Esquire ever. So yeah. Affidavit of Erlinda O. Johnson, Esquire. So I, Erlinda O. Johnson, being of age of majority, do hereby attest to the following. 1, I am a duly licensed attorney in the state of New Mexico, in good standing, and authorized to practice before every court in the state of New Mexico, the United States Immigration Courts, the United States District Courts, and the District of New Mexico, the United States District Court for the Western District of Texas, the United States District Court for the District of Colorado, and the United States 10th Circuit Court of Appeals. Okay, I don't care. I have been practicing law for over 28 years. That I care about a little bit more. I don't really care about what admissions she has. My office is located in Albuquerque, New Mexico. Albuquerque, New Mexico is really what I think about for, I think of Breaking Bad or like Bugs Bunny. But on April 16th, 2024, I was appointed to work as a special prosecutor on State v. Baldwin as co-counsel for lead special prosecutor Kari Morrissey. Kari Morrissey did not give me an expert report referenced as the third Hague report prior to the defense's pretrial interviews of the experts. Kari Morrissey did not tell me the third Hague report existed prior to the first Hague PTIs. Kari did not tell me about the third Hague report until May 21st, 2024. Had I known of the third Hague report, I would have disclosed it to defense counsel. Approximately 2 or less weeks prior to trial, defense counsel emailed me only. That's a whole sentence. We're going to come back to that. Emailed me only, asking me to review a production provided by the district attorney's office to the defense pursuant to the Inspection of Public Records Act for discoverable material to disclose to the defense, as the IPRA production had been heavily redacted by the issuing agency. So, emailed her only. Let's talk about why you do that. You do that when you think that Kari Morrissey is an unethical sack of shit, and you are trying to deal with the prosecutor that you trust. That's what they're doing there. She's basically saying, defense thought I was the good one. Oof. We're hearing some real interesting things here, right? I am thinking that Kari Morrissey and Erlinda Johnson probably are not on good terms, and that Erlinda Johnson is getting up to tell the truth, and she don't care who burns. She's like, I'm just going to tell what actually happened, and whoever gets burned by this tea, should not have been in the fucking splash zone. So, yeah. Kari Morrissey is going all the way under the bus, but this is interesting. This is real interesting. Kari Morrissey suggested to me that I ignore the discovery request from defense counsel. I told Kari Morrissey I would not ignore defense counsel's email, as I had my own ethical obligations to ensure the proper discovery was disclosed. I then asked 2 private investigators to assist me in reviewing the nearly 5,000 pages of the IPRA production for the purpose of unredacting everything to which the defense was entitled. I conducted a review of the redacted IPRA material and compared it to the unredacted version. I also reviewed the materials the investigators unredacted. After conducting the review of the IPRA production, I uncovered additional items to disclose to defense, which amounted to thousands of pages of documents. Whoop. And now I've lost my page there. Kari Morrissey instructed me not to talk to defense counsel over the phone. Now, there are times when you don't talk to lawyers or over the phone. If you are a lawyer and opposing counsel says, please conduct all communication by email, what that means is that they think you're a slimy sack of shit. Now, I suspect that Kari Morrissey told them not to talk, or told Johnson not to talk to defense counsel, because she thought that defense counsel are slimy. And she might be right. You know, she might also be accurate. It seems to me like everybody here has some issues, except Erlinda Johnson, who seems to be clothing herself in glory here. Trial began on July 9th. I resigned from the prosecution on July 12th during trial because I learned of undisclosed evidence during trial and felt that my ethical obligations called for me to withdraw. I did not resign from the case because I did not want a public hearing on the discovery issues. So she's specifically contradicting Kari Morrissey here. During the lunch hour on July 12th, I advocated for Kari to dismiss the case against Mr. Baldwin. And during the break in the morning and lunch hour on July 12th, after conducting legal research and evaluating what I learned that day about what had transpired with the Teskey ammunition evidence that had not been disclosed to defense, I believe the right thing to do for the state to do was dismiss the case on its own motion. But Kari Morrissey disagreed. Further affiant saith not. Yeah. So let's talk about what I would do if I were in Kari Morrissey's shoes right now. And that is, I would send in a new filing, and it'd be real short. It'd be under the 10-page limit. Real short. It would just say, state withdraws our motion to reconsider and invites the court to dismiss it. Real short. Basically, make this go away, please, would be the entirety of what I would file. Please go away. And if I was the judge, I'd say that is a wise choice. It is gone. But I don't think that's what she's going to do. I don't think that's what she's going to do. I think she's going to dig further. And the most hilarious thing she could do to keep digging. Now, the judge may also, if the judge really, really wants to throw Kari Morrissey a fucking life preserver, what I think the judge does, if she wants to save Kari Morrissey from herself and basically step in and be like, stop slamming that car door, she'll just say, I am dismissing your 10-page or your 11-page memo as it was filed outside the time limits. Done. Dismissed on procedural grounds. End of the matter. Right? But the judge could decide to hammer her to the wall, right? The judge could absolutely decide to hammer her to the wall. So, yeah. How does this turn into maximum shit show? If we want to take this shit show into maximum overdrive and like aim it directly for the pig field, for maximum shit flinging whatever. Well, the way you do that is if Kari Morrissey turns around and says, I want to cross-examine on this affidavit of Erlinda Johnson. If Kari really wants to turn this into an absolute shit show, she tries to cross-examine on this affidavit and says, I wanna bring Erlinda Johnson in under oath and I want to ask her questions. And thing is, it's freaking insanity to do it. That would be insanity. But Kari Morrissey has not shown us signs that she is entirely stable at the moment. So there is some real possibility that this just just turns into something insane. So yeah, I don't know. I just don't know. Yeah, I don't know what to say here. This has gone completely crazy. And it's just, there is no reasonable way that this yeah, so I don't know what ends up happening with this. So all right, now I'm just trying to see what is it, where should we go next from here? We should do a swoop, and I should read some super chats. Swoop. All right, let's go through some super chats, and then we're going to talk about a lawyer who is doing worse than Kari Morrissey. A lawyer that is that has made worse decisions than Kari Morrissey, and we're going to talk about that after we go through super chats. So Jada Jur, thank you for the 10 gifted memberships, much appreciated. Alan Muller, I know Rust is hair raising, but I didn't think Kari had a wig, much less a toupee. Lady Fang got sent a D-pic to work email by a patient. Ugh. Guys, if anyone out there who you have not been married to for like 30 years is asking for a D pick, they're probably a scammer. Probably a scammer. So, yeah. BL, sell a PDF of Runkleisms in your shop. No stock required. I will probably sell like a calendar. Phoenix Paw, to get on your nerves, seeing as you hate being gifted money. Hate it so much. Thank you so much, Phoenix Paw. Kristen M96, Hogue Shop is on Shopify. Is there a chance Mrs. Hogue can help? Can you send her an email and ask? I can shoot her a message. Light Queen, good evening from Vancouver Island, Canada. Love Mondays with Runkle and Fridays with Rob and Ian. Thank you so much. Joy W101, spending my birthday with all of you in the Dominican. Life is good. I wish I was in the Dominican. I'm not in the Dominican. Lauren, Bukaki lost 5 vacation days for Proctor's texts. We're going to talk about that. Maybe we can talk about that first. I don't know. Marvin CZ, thank you for the 10 gifted memberships. Much appreciated. Catherine Fraser, Carrie, let it go. Let it go. Yeah. Kate, maybe, can they charge her with perjury? Theoretically, yep. Now that they have the affidavit from Erlinda confirming she lied under oath, she's getting close to a perjury charge. I don't think they will, but it's concerning. They can't both charge her with perjury and let her continue being special prosecutors. They got to pick for one or the other. So, Sandy, thank you for the 10 gifted memberships. Swifty Sue says, people could gift you land. I don't think that's likely to happen, but okay. Okay. Canonical Heat, almost to 2 years. Very close. And thank you so much. A donation for Ian to Extra Life would be nice. And all the YouTube stuff, you know the drill. Like the stream, share the stream, subscribe to see more streams. Yes. And my Extra Life is listed on my Twitter. It's the pinned post, but also it should be there. So, Hither Creator, love your content, Runkle. Stay safe and keep it up. Thank you so much. And Canonical Heat, thank you for the 20 gifted memberships. Much appreciated. Marguerite Brody, hi, Runkle. I've been wondering about Hancock. It seemed pretty clear she was lying about her endless attempts to call Teskey. Could she be charged with perjury? Could, but they won't. I don't think they will. Kelly's Corner says, add quarter teaspoon matcha, and it's a dragon's last word. Interesting. Dictator saying, would you look at RV or the Queen and Campbell? Neat case, and I just find Lauren Campbell a neat guy. I'll have to look that one up. Charles Vance, Spiro's last word, 3/4 ounce tequila, 3/4 ounce green chartreuse, 3/4 ounce maraschino cherry, or maraschino liqueur, 3/4 ounce fresh lime juice, dash of chili bitters, optional for a spicy kick, ice jalapeno slice for garnish. Love it. Dr. Moo, thank you for the YouTube membership. Much appreciated. Fiona W., thank you for the 10 gifted memberships. Charles Vance, thank you so much. And I got to roll this. So Esquire is a throwback to English custom esquire or squire to a knight, slightly higher than a gentleman. It's an honorary title of nobility, and if a non-lawyer affixes it to his letterhead, it pisses off the lawyers mightily. What if they're actually a squire, though? Moonshine 35 for the Kari Self-Awareness Fund for self-destructive lawyers. Nice. Jackie Lindy, when does the judge send a bar complaint on Kari's behalf? Might happen. Peyton Weismiller, I'm dying to try your hot sauce. Where's the best place for updates? When it goes able to be sold, I'll post on Twitter. I'll post on YouTube. I'll post on Locals. I'll post on Patreon. I'll post on all the places. And Elfligans, forever chasing Canonical Heat. Well, fair enough. All right. So I guess let's talk about the new news that's been posted about Trooper Bukaki. Trooper Bukaki. Okay. That's not his actual name, but it's the name we're running with here. So, investigator and Karen Reed to forfeit vacation days over handling of Trooper Michael Proctor's texts. So, State Police Sergeant Yuri Bukenek, who was one of the lead investigators in John O'Keefe's death, forfeited 5 vacation days following an internal investigation. A spokesperson for the department confirmed Monday. So, what is he being dinged for? He is dinged for being in the group chat and failing to report Trooper Proctor for being essentially a bag of dicks. And not just like, not high quality dicks. These are like selected for size small and extra bumps. Yeah. So he has forfeited 5 vacation days, and that is the final outcome. They note Sergeant Buchanan did fail to conform to work standards established for his rank, title, or position when he failed to properly supervise or counsel a subordinate for sending inappropriate correspondence regarding an ongoing investigation. Buchanan should have both reprimanded Proctor and reported the texts. So, now I've got some thoughts about this. And the thoughts are, this is basically like fuck all, right? This is a slap on the wrist, but it's not even like a slap on the wrist with like a belt. It's a slap on the wrist with a feather duster. And somebody's saying, is this 5 per year permanently or just 5 this year? It's just 5 this year, right? It's just this year. So it means that he's going to have to work 5 days that he might otherwise have spent going to Bermuda, or, if he felt like it, covering up a murder. That's another use that somebody could theoretically do with vacation time. I'm not saying he did, but it is a funny joke. Like, 5 vacation days, that's not a lot. The value of the 5 vacation days, I feel like the value of that is pretty low overall. Yeah. Yeah. The other thing is, I kind of am not super thrilled about him losing vacation days, because I don't want him working. Like, oh, he's going to be working more. He's going to be working extra days. Well, but he sucks at his job, right? We just determined that he sucks at his job. So, yeah, that's not good. What else is going on in the Karen Read trial? Well, they brought on a special prosecutor. And I think that was a good idea from the perspective of, if they want to get a conviction, it's a good idea. Why is it a good idea? Well, because they badly need credibility on this case, and they don't have a whole lot. So maybe this new special prosecutor will bring in some credibility that they badly need. So that might be a help. The other thing is, I think the current side needs some help for, like, let's have a look at this. I don't know. That said, I'm okay if they just like bomb this case, right? I'm okay if this just bombs out, but all right. So that's sort of what's going on with Karen Read. There's not a lot of development. A lot of people want to read in a whole lot of about what's going on here, right? A lot of people basically say that they want to, that they're having all sorts of theories about, about what this means and the larger significance, and what all this involves and so forth. And the thing is, is at the end of the day, I don't know that anything really comes of it other than they brought on another person and they and maybe they'll get some new perspective. I don't think that this is super I don't think that this is super momentous, but we'll see, right? I also just wonder, does this new guy, how much autonomy is he getting? How much autonomy is the new guy getting? Because there is the possibility that they hand this off to a special prosecutor and they say, you get to decide what you want to do. You get to decide what you want to, what is appropriate here. And it could be that he says, yeah, and I've decided that the appropriate thing is to kill this case, right? That might be awesome. So, yeah, we'll have to see. I see some requests to stream the Canton police audit meeting. I could have a look at that. Yes, I will continue covering Karen Reed. Karen Reed is interesting to me, so I will keep covering it. It's going to be a while before anything super momentous happens. This is a good question here. Can the sus witnesses polish their answers in the second round of Karen Reed trial? Yes and no. And what I mean by that is that they can try to improve their answers, right? They can try to put a different spin on it. They can try to describe things a little bit differently. But here's the thing. There's an old rule of thumb. If a complainant is providing a statement against my client and they provide one statement, well, then that statement might really hurt my client. But if they provided 3 statements or 4 statements, then I'm feeling pretty good. Because if you change your story, then that looks awful to a jury. The thing is defense lawyers, one of the things that defense lawyers do is we get really good at pulling up or at using your own words against you. You say something and then you say something different, I'm going to impeach the fuck out of you on that. And sometimes it's not even that much of a big difference. Let's say somebody the day of the event says it was sunny, right? They say it was sunny. At trial, they say it was raining. And why do they say it's raining at trial when they said it was sunny on the day of to the police? Well, it's probably because they forgot. It's probably that it doesn't mean anything, right? That they don't mean anything by it, that they just, that they just forgot what the weather was. But I'm now going to say, really? You forgot? Like what the whole sun was doing? You forgot that? You'd agree it's easier to see something in sun versus rain, right? You'd agree that if you were in the rain, you'd be getting wet, right? You'd agree that if you're, getting wet, you might have an umbrella, you might all of these. You'd agree that that's a pretty significant difference between these two versions, right? So you didn't even know what the weather was that day? How's this jury supposed to believe anything you say when you don't have your story straight? Right? Now, that's on something that is probably tangential and trivial. Remember how bored we were about hearing about how it was snowing from everybody? But if they're trying to fix their testimony on something a little more significant, like let's say Trooper Paul comes out, right? Trooper Paul comes out and says an entirely different version of how the accident happened, right? He says, oh, now it's very different. and he tells a new version of how, he thinks that things went down. Well, then I would absolutely be hitting him with his previous testimony, his previous statements. And the thing is let's say they say, you know what? If the prosecution says, you know what? Fuck Trooper Paul. He was awful. We're going to bring in a new accident reconstruction guy, and he's going to be much better. If I'm the defense, I call Trooper Paul. And I make Trooper Paul get up on the stand and tell us about his great version and how it's completely different. Right? So, yeah. All right, let's cover the rest of the super chats here and move on to talk about a truly hilarious lawyer. So Claude Sibian, tempted to vote Trump versus Harris based on who will let you sell your sell us your hot sauce. Try industry sour, chartreuse, Fernet, lime juice, simple syrup. Ooh, I don't know that any of them will change those FDA rules. SF in Texas, 6 months and counting, enjoying every moment. Glad to have you here. DSN says thanks for the membership and thank you for 5 gifted memberships. Much appreciated. Moonshine 35. Can the witnesses? Oh, we just covered that. Yes, they can sort of do it, but it'll probably blow up in their face. All right. Let's have a look at the let's have a look at a story that this is a story that I really had some ethical quandaries about, and I'll explain why. So, District Attorney's Office welcomes new prosecutorial staff. Okay. So District Attorney Keith Higgins announces the following new hires to the prosecutorial staff of the District Attorney's Office for the Brunswick Judicial Circuit. So they welcome, a guy who has, or Whitney J. Feltzer Gregory, who has, run a special victims unit, which did adult bad things and other bad things, complex domestic violence cases, complex murders, child murders, and domestic and other murders. So really, really the bad files, right? Really, really the awful files. Okay. Sounds pretty awesome. One of Deputy Chief Gregory's many notable prosecutions include a first-degree murder case in Virginia where the defendant used a .22 caliber rifle to shoot and kill in cold blood her mother and sister in their own home and then staged it to look like a murder-suicide. The motivation was greed, and the defendant was found guilty following a 4-week trial and sentenced to 2 life sentences plus 8 years. You got to serve life, and then another life, and then 8 years, just because fuck you. Okay, sounds pretty good. Sounds awesome. All right. Next person worked in private practice, litigating workers' compensation claims. Okay, not so interesting. Melanie Fenley, but JD cum laude from Atlanta's. Okay, cool. Sean P. O'Brien. Okay. Previously worked as a major crimes prosecutor. As such, he prosecuted violent crimes, which included murder, armed robbery, aggravated assault, home invasion, and other violent felonies. All right, so those people are all themselves, right? They're all like no issues with those folks. And then we have DA Higgins welcomes Assistant District Attorney Mark J. Blunt to the staff of the Appling County / Jeff Davis County office of the BJC. ADA Blunt received his JD from the Duke University School of Law, and he also attended the University of Michigan Law School. He received his BA of Arts in History from Southern New Hampshire University, Manchester. ADA Blunt is barred in Georgia, Missouri, and Tennessee, and is a founding partner in his own law firm. Now, I just want to say that founding partner in his own law firm is not actually that impressive. Because you want to know what it takes to found a law firm? Nothing. All it takes to found a law firm is you just decide to do it, and you might have to file some forms, and you might have to pay a filing fee in the amount of like, maybe a few $100s, maybe. But like it doesn't take anything to founding a law firm is something that is like founding your own law firm might be that you've got an entrepreneurial spirit and that you want to get one started, or it might just be that you applied to work everywhere else and nobody would hire you. Right? Right? Because it could be that you just tried your best to get hired, and everyone was like, nah, fuck this guy. So, who is Mark J. Blunt? Well, Mark J. Blunt is notable for a little known case called Blunt versus the United States of America. At least I think it's the same Blunt. And why do I think it's the same Blunt? Well, amongst other things, comes now plaintiff Mark Jerome Johnson Blunt, gentleman Esquire, Juris Doctor, graduate of Duke University School of Law, and scorer of a 173, the 99th percentile on the law school admissions test. And I'm going, wow. By the way, filing your LSAT is a major party foul. You just don't do it. Now, I am not 100% certain it's the same guy. I believe it's the same guy because of all of these, because of those corresponding details. But I can't say for certain. It's possible there's another Mark J. Blunt out there. It is theoretically possible. Now, the other thing here is that he filed... remember the thing we were saying about, page limits? Well, this is what he filed. It's 189 pages. 189 pages of bullshit. And he notes Georgia bar number and Missouri bar number. He's barred in Georgia, Missouri, and Tennessee. So Georgia, Missouri, it's starting to match up a lot, right? It's starting to seem like maybe this guy is the same dude, right? He also, by the way, filed his family genealogy. All of these family members who are like, keep our name out your MFing mouth. So here was my ethical problem. I considered phoning the district attorney's office because They have members of the media. That's me. I'm a member of the media. Members of the media with further questions may contact the Brunswick Judicial Circuit District Attorney's Office at the number. And I really, really wanted to phone them and just be like, can you confirm that this is the same dude? And if it is the same dude, did you know about this? Like, did you know that he is like, did you know that he is renowned on the internet as an absolute circus? And I don't mean the entire circus. Like, he's not the knife thrower or, the trapeze act, because those are people with skills. He is the clowns and the monkeys. That is the portion of the circus that he is. So, yeah, this guy is all the clowns and all the monkeys. And now here's the thing. I don't want to get him fired necessarily. I think that there are probably jobs that even an absolute, I don't even know what to, describe this guy as in terms of his skill level. Yeah. Even an absolute idiot like him, I just go like, okay, there might be a role in law that he could do. Maybe he could be a patent examiner. I'm just kidding, because I know Uncivil's in the chat. But this guy is actually I'm just teasing. That's it. There could be a role for him, in the legal world. The problem is that I don't think that having people's liberty in his hands is the role here. And why don't I think that? Well, let's talk about his filing a little bit more. Let's talk about his filing a little bit further. So, what did he do? He wanted to own machine guns. He wanted to own machine guns. And I mean, I get it. I want to own machine guns too, right? Fair enough. He wants to own a machine gun. I get the dream. I get, he wants to dream the impossible dream and own a machine gun. But what he did was he filed a suit that alleges that he is a very special boy and that he has special legal powers to own machine guns by virtue of being a member of what he calls the posterity. The posterity. What does it mean to be part of the posterity? Well, he is saying that his family dates back to before the U.S. was a country, and therefore he has special rights that existed before the U.S. became a country, and that he gets to keep, and that that later restrictions don't apply to him because he is such a special boy. And he had some case law to note that he had some case law to cite in favor of this. And you might think, oh, well, it's got to be real hard to find case law for that. Well, the case law that he found is a case that is famous. Case that is famous. Uncivil used to do, I don't know if he still does, but he used to do a thing where he'd say I forget what the price was. It was like $200. He said, I will cover any case you want for $200. And there was one case that he said he would not cover. One case that he said, I am not covering this case no matter how much you pay me. That case is Dred Scott. I was banned once from Uncivil Law's Discord because he was saying, like, what should I do or something? And I said Dred Scott. And I was, like, banned instantly. And I deserved it because I was trolling like a bastard. So Kurt banned me, and I deserved it so much. So let's look at what he has to say about the unique case of Dred Scott v. Sanford. Now, keep in mind, he's arguing his unique rights. Even the first Supreme Court case on the subject, Dred Scott v. Sanford, made note of the fact that if freed blacks were to be considered citizens of the United States under the Constitution, that they would then be within their rights to enter every other state whenever they pleased and to keep and carry arms wherever they went. Even though it cannot genuinely be maintained that freed blacks would have ever been considered to be members of the militia, organized or otherwise, in the states of the South where slavery was still extant and the threat of slave revolts constant. Yeah, using Dred Scott for the proposition that some Americans have more rights than other Americans is holy shit. Holy shit. And if the guy does have this kind of racist notion, he absolutely should not be running a prosecution, because here is what is going to happen at some day in the future. Here is what is going to happen. He is going to be prosecuting a black person. Black people get charged, right? It happens. And he's going to fuck up on like a Brady issue, right? It's just going to be, there's going to be some missed Brady issue. And the defense is going to say, not only did you fuck this up, but you fucked it up because you are an absolute racist sack of shit. And they're going to cite to his previous case with Dred Scott. And he's going to have to answer to this particular issue. Or he's going to have a jury trial. And he's going to end up excluding more black people from the jury than white people. And the defense is going to say, you're a racist sack of crap, and that's why you excluded those jurors. And this creates a real problem for the state of Georgia. So, yeah, I'm going to say if I was a district attorney and I got an application from a certain Mark Jerome Johnson Blunt, LSAT score 173, then I would not hire him. I would set fire to that resume, sprinkle it back into the envelope, and mail it back return to sender. Yeah. Yeah, I just don't get it. The other thing I will mock him over every chance I get is scorer of a 173, the 99th percentile. Every lawyer knows not to drop your LSAT score because nobody cares once you're a lawyer, and it just makes you look like a wanker, right? It's like dropping your LSAT score as a lawyer is a little bit like if you are in your 40s and you start telling everyone how you were the little league champion. It's like, cool, good for you. But yeah. So but here's the other thing. 173 leaves a whole 7 points to be better than him. And without dropping my specific LSAT score, Blunt, step up your fucking game, dude, because I beat the crap out of you. So yeah, I had fun, by the way, on Twitter, because he was tweeting about how he has this great case and how he's gonna bring machine guns to to like Americans. Well, I had fun asking him, like, you got a 173, what, were you drunk when you took it? So yeah, I had fun with that because all right, enough of that idiot. Enough of that idiot. Let's cover the super chats here. Lady Fang, did you hear about the sheriff who pew-pewed a judge? I did. I'm not going to cover that yet. And the reason why I'm not going to cover it yet is that we don't really know why. We know he shot a judge, but we don't know what was going on there. And so I don't really want to say too much about it until we have a little bit more information. Because, yeah. Al Shirley, he was the simpleton hire. He seems to be. Jackie Lindy, I have a good friend who's a professional clown and gets upset when his profession is dragged through the mud. Can we use another job type? Fair. Fair. Can I just go with the monkeys then? Is the monkeys good? Clay Olson, thank you for the new membership. Much appreciated. Hopefully the monkeys is still good. I don't mean the music band. I mean just the monkeys. I also want to argue with this. Runkle is just that smart. It's not that I'm super smart that I did well on the LSAT. It is not that I am like some super genius. As much as I would love to tell you that I was some super genius and like, that my brain is this pulsing, no, that is not why I did well on the LSAT. The reason why I did well on the LSAT is because I grew up reading books of puzzles, and I grew up playing games like Myst, and I grew up playing D&D, and I grew up playing all of the doing all the nerd puzzle shit. And so when I had all the nerd puzzle shit down, it made it easier, right? Because it was just, it's a puzzle game basically. So I am kind of used to that. And even getting rid of the logic games, the reading comprehension and logical reasoning is itself a kind of puzzle, right? So, do I play Catan? I don't play Catan. I don't much care for Catan as a board game. I do play a lot of other board games, though. So, yeah. All right, let us do the spicy swoop. Let us do this one. How does D&D help with LSAT? You know how many how many logic puzzles show up in D&D? All the time, right? They're just all the time. You get logic puzzles in D&D games. It is super, super common, and yeah, it's just, yeah. I am a total nerd, and yeah, that is sort of what it is. So let's just see here. All right. So I wanted to talk about wills, and I wanted to talk about social media. What do we want to talk about first? Do we want to talk about wills, or do we want to talk about social media evidence and how the news is dumb? Because this is also partially a story about how the news is dumb. So what do people want to talk about first? I just going to give the chat a few moments to sort of tell me what they're thinking. Aya says Hurdy sticks. Aya wants the Hurdy stick. Hurdy stick. All right. I'm seeing wills is coming up a lot. Okay. Let's talk about wills. I'm just going to move a story up here, and we're going to have a look at it, and then we're going to look at the case. So, going to just pull this right up here. BC court overrules biased will that left $2.9 million to son and $170,000 to the daughter. So, basically, the mom died, and she left almost all the money to the son. And the daughter was like, that is not cool. Why is the daughter like, that is not cool? Well, because the daughter would much rather have half of 2.9. Like, if there's $3 million, the daughter would much rather have 1.5 million versus 170,000. Now, this is the thing, is that on one hand, you might say this is unfair, right? This is unfair that she got this shortchanging in the will. But let's look at the other side of it. The other side is basically, hey, it's my freaking money, right? Now, I just want to note there are some rules about what I can and can't do in my will. For example, I can't completely disinherit my wife. But, like, let's say my brother pisses me off. I don't have to give him shit. Actually, I think that currently I'm not giving him shit unless my wife dies before he does. If my wife dies first, then he gets a whole bunch of stuff. Mr. Runkle, my brother, do not kill my wife. I will be very upset, and I will change my will if you do that. I don't think that's seriously a risk. But so the thing is like, how do the courts deal with this? Because I kind of think that generally, now, I just want to note here, sometimes parents have really good reasons. Sometimes parents have really good reasons to cut a kid out of the will. Why might the parents cut the kid out of the will? Well, let's say I have 2 kids, and I actually have no kids unless you count the dogs, which I don't. But let's say I got 2 kids, and one of the kids, one of the kids like sets fire to my house because they're a psychopath, and the other one is like, out there feeding the poor. Well, I might want to give more money to the one who's out there feeding the poor versus the one who is like setting fire to orphans, or myself. Maybe the son has special needs, right? Maybe he needs that money to provide for him because he's got special needs, right? And needs that money in order to sustain himself because he's not able to work. But in this case, the argument was that there was a gender-based bias that was argued as traditional Chinese, traditionally Chinese. Also, where does this money come from? Lamb's father won $1 million in the BC 49 lottery. Now, the other thing is, let's say I don't have a good reason, right? Let's say I don't have a good reason for wanting to divide up the money the way I do, right? Let's say I got 2 kids. And let's say my reason for dividing up the money the way I do is I just think it would be funny if they fought after I died, right? Like, it might literally be that I think that it would be funny if they got into a fight. And so I give all the money to one of them. And to the other one, I leave my underwear. Not the clean underwear, only the used underwear. It's still my stuff, right? It's still my stuff. So, yeah, I don't know. But British Columbia has laws that limit that. And we can look at the case. Because the news report, I'm going to give credit to the Vancouver Sun. Credit where credit is due. The Vancouver Sun linked the decision. Good for them. But yeah, let's have a look here. All right, we're going to embiggen. So Ginny Lamb and William Lamb in his capacity as the executor of the will of, yeah. All right, reasons for judgment. And you can see all of this, all of this sort of stuff. Now, we're not going to go through every bit. We're going to skip over some of that. But the plaintiff, Ms. Ginny Lamb, seeks to vary the will of her mother pursuant to Section 60 of the Wills, Estates, and Succession Act. So, I should have had this ready to go, but I didn't. Because normally these things are linked, but in this case, it is not linked in the decision. So we are going to have a look at Section 60 of that law. Because if we're going to understand this, we should understand this. So, maintenance from estate. Despite any law or enactment to the contrary, if a will maker dies leaving a will that does not, in the court's opinion, make adequate provision for the proper maintenance and support of the will maker's spouse or children, the court may, in a proceeding by or on behalf of the spouse or children, order that the provision that it thinks adequate, just, and equitable in the circumstances be made out of the will maker's estate for the spouse or children. Now, this provision was originally intended to be like, hey, this is, if you, let's say you've got somebody who's been a stay-at-home mom, like, and they have like no useful working skills right up until they're 60, and then their husband died, and the husband leaves them no money, right? Notwithstanding that they had then the court, this is what it was supposed to be there for, is so that they can't be like, okay, this 60-year-old woman who's been married to this dude for however long, but the assets just happen to be in his name, that she doesn't end up on the street, right? Okay, fair. Fair. But it seems to me they're extending it a little further. She may have no useful skills that you can do for work. Yeah. You got no skills that are going to make you any money, right? And at 60, you're probably not looking forward to going back into the workforce, right? So, yeah. All right. So, Ms. Lamb relies on significant gifts that her brother, Mr. William Law, received from their mother before her death, coupled with his preferential treatment as their only son. Mr. Law takes issue with any variation of the will, arguing that there's no principled basis on which his mother's testamentary intent should be compromised. He denies any discriminatory or preferential treatment by their mother and submits her testamentary intent should be followed in its entirety. So a lot of people were saying, listen, why wouldn't the brother just work with her and split it? Well, because he's like, fuck you, I get the 2.9 million. And I've heard through the grapevine that that he plans to appeal this decision. So yeah. He's planning on, yeah. So yeah. All right. Skipping ahead a little bit. So on March 17th, the mother executed a will, 2004, which appointed William as sole executor. She made a specific gift of $2,000 to Ginny and left the residue of her estate to William. So originally, from the 2004 will, she was going to get $2,000. Be it known that the reason that Ginny is only receiving this my bequest of $2,000 is because Ginny has already received in October 2002 from me funds totaling $120,000 of lawful money of Canada, which funds came from the equity in my property located at 2555 Venables Street, Vancouver, British Columbia. Okay, so she's saying she already got $120,000, so she's only getting... Now, when you're talking about like 2.9 or $3 million estate, saying she already got 120 doesn't seem all that, like, yeah. So, okay. Parties agree that the family home was a specific gift to William in 2004. She gave him the house. The mother did not execute a gift deed of in relation to the transfer, and William was put on the title of the family home as a joint tenant. Joint tenancy. What is joint tenancy? Joint tenancy basically means that when one of you dies, the other person gets everything without it going through the estate. So my wife is a joint tenant on this property that I live in right now, which means that if I die today, like if I die midway through this live stream, and against the tide, I know I'm not allowed, but if I die right now, you know, on this live stream, Mrs. Runkle just owns the house. Cool. Right? All right. So, at the time the 2004 will was executed, the estate consisted of her rental property, bank accounts, investments, and her personal and household items after placing William on title to the family home. Approximately 2 years prior to the time, she sold 2 of her rental properties and gave approximately half of the net proceeds to William and gave nothing to Ginny, right? So she got nothing. William got 2 or half of 2 properties. But then she made a third and last will, which provided in part the property I owned at 2555 Venables Street, shall be transferred to my son, namely William Law, for his use absolutely. The rental I owned at 1194 East 18th Avenue shall be transferred to my son and my daughter in equal shares. Of course, was that the one she sold? Nope, she still had that one. Okay. So they don't agree on the value of the gifts he received prior to the death. But she says that he got a sum of nearly $3 million, which amounts to 82.6% of the estate. Okay, so that's what she's noting. She says that the total value of the gifts she received was $170,000, accounting for inflation. He acknowledges that he got the greater share. He says, yep, I got a bigger share. Tough. But he does dispute some of this. He says she's overvaluing it. And he also says that this acknowledges the lifetime work he did in managing the rental properties. Okay. Family background. We'll skip some of this because it's just not super interesting. But the evidence as a whole, including Ginny's clear and consistent testimony, established that Ginny played a major role in caring for her mother, particularly after her father's death. For example, Mrs. Law insisted on staying with Ginny at Ginny's home for medical care, assistance, and comfort following surgeries and significant health events. Such care included she underwent heart valve surgery, and she took care of her after that. Another major heart surgery, Ginny took care of her mother after that. Cataract surgery, took care of her after that. Second cataract surgery, took care of her after that. Third cataract surgery, I guess she's got 3 eyes. Taking care of her after that. Pacemaker surgery, stayed at her house for a night after that. Basically said that, that Ginny was doing a lot in her life, but also William was heavily involved. So it wasn't a situation where he wasn't, heavily involved. So let's get to part of it. They found that William gave conflicting evidence. They note, I do not accept William's evidence to the effect that he did not play a key and central role in managing his mother's estate assets and finances after his father's death. So they're saying, maybe some dishonesty there. Evidence regarding Mrs. Law's preference for sons over daughters. So I find that Mrs. Law held the view that sons were entitled to most or all of a parent's estate rather than daughters. This bias influenced and informed the gifts she gave to William and Ginny throughout her life and was also reflected in her 2018 will. I accept Ginny's forthright and clear evidence that her mother told her again and again in casual conversations over the years that William was entitled to the estate assets and that he would inherit most of the estate because he is the son. For example, Ginny testified that these repeated assertions by her mother included conversations between Ginny and her mother dating back to a time after her father died, as well as a conversation Ginny had with her mother when she was tending to her mother in a hospital emergency room years later. So here's the thing. So the court basically said, hey, listen, this is unfair. She was biased, and so then we're going to correct this and split this up. And they say, what is just and equitable in these circumstances. Now they cite to a case that is an important case, Tatterin and Tatterin Estate, which said that financial need is not a necessary condition for a successful wills variation claim brought by an adult or independent adult child. So basically, they can just say where an adequate provision is not made, the court can divide things up. So, what is the ultimate takeaway from this? Well, the ultimate takeaway from this is that Canada feels very much entitled to mess with these kinds of decisions and to basically step in after the fact and fiddle with them. And what does that mean? It means, amongst other things, that if you want to do anything unusual with your will, you better hire a lawyer. And you better hire a lawyer who's aware of all of these issues. Because if you try to make a will that leaves somebody out, that's not okay. The other place where people really, really run into this problem is people who choose not to get married. Because what you'll see people who live together, but they choose not to get married, right? And the reason why they choose not to get married is because they don't want the government in their business. They don't want to deal with the potential issues of, like, alimony or palimony. They're like, no, we don't want the government deciding what happens if we break up. We just want to be able to break up cleanly and crisply and no problem. So, what have the courts in Canada done? Well, courts in Canada have typically said, listen, tough shit. You guys have been living long enough with each other. You're common law married. You've got a common law relationship. And so, even though you tried not to be married, we're deciding that you're effectively as good as married, and that we get to intrude in your business. And yeah, I don't know. I can see the arguments for, like, what is the unfairness here? But the other thing is, don't we put some value on property rights? Like, don't property rights mean anything? Because at the end of the day, if I work real hard, right? Let's say I work really, really hard, really, really hard, and that I just, like, okay, cool. This is my stuff. Mine. Let's say I got, let's say I've got 8 kids. And let's say because those kids were raised by some sort of asshole, that they turn out to be horrible people. And I'm like, oh shit, I regret everything. So instead of leaving any of the money to the kids, I leave it all to, like, a charity for, like, I don't know, that rehabilitates injured goldfish. So, and they're like, not only did he leave it to, not only did he leave all of his money to a charity, but he left it to a stupid charity. Like, he left it to an idiot charity. Who rehabilitates a goldfish? You just, flush, right? But that should be my call, right? That should be my decision. So, if you're trying to do anything with your will that is, like, basically hire a lawyer for your will. And I don't know if she did hire a lawyer for her will, but hire a lawyer for her will or for your will, because if you want to arrange any sort of, unusual division, then it might get meddled with, and you need a lawyer who can tell you, like, you can't do that, right? This also comes up every once in a while when somebody tries to set up, like, a trust or a scholarship. And really where it comes up with trusts or scholarships is like, let's say I decide to set up a scholarship and I decide to set up the most offensive scholarship around, right? The scholarship goes to like, it like you decide to set up a racist scholarship or something like that. The court can step in and be like, no, we're not doing that. And the thing that ends up being funny is that there have been some people who've tried to set up racist scholarships. They're like, this is solely for like white males of Anglo-Saxon descent. And okay. And then the court steps in afterwards, after they've put in like, $100 million towards this like continuing scholarship. And they're like, actually, those conditions on that money are illegal. So now the scholarship can be won by anybody. So anybody can win this scholarship. And it's like, would the person have actually made that scholarship if they knew that? Maybe or maybe not. Trisha Lynn for the win. I don't know. It's tough. I mean, even in life, you can't necessarily do anything you want with your money. For instance, if I want to buy a piece of land and maintain it as a giant pit with spikes in it, the city will step in and be like, you can't do the giant pit with spikes in it. I know you really want the pit with spikes in it, but you can't do the pit with spikes in it. Sorry, no pit with spikes. So yeah. All right. Let us have a look at another interesting little let's cover some super chats, and then we're going to cover something else here. Maverick Angel says, time flies when you're having fun, referring to the 14-month anniversary there. Awesome. Dr. Moo says, this is to help buy one land. It may not buy much land, but it's a start. I hope that in time it may become part of Ruggleteria. Working on it. Linda Santiago, thanks for the great Mondays. Thank you. Mrs. Squirrel, where there's a will, there's a relative. I love it. Jenna Berdal, I'm a bit behind in the stream, but Caesars are quite popular in North Dakota. We must be close enough to Canada. They're a tasty drink. All right. So let us have a look at this case, because this case is an interesting one. Murder case collapses against Toronto rapper Top 5 after judge tosses social media evidence. Okay. And this is Top 5 on the left. The guy on the right is the guy that got murdered. Yeah. Oh, people are demanding a swoop. Demanding a swoop. Apple Silver Ian, what happens in Canada if you don't have a will? If you don't have a will, then there is a law that provides that your stuff goes to there's like a chain in Alberta. There's a chain of people who get it. It's like, if I don't have a will, first it goes to my wife. If my wife isn't alive, then it might go to my parents. If my parents aren't alive, then it might go to, then it might go to my brother. And if you just run out of next of kin, right? If you just run out of them, the last family member that it goes to is always the government. If you die with nobody else around, government takes it. So, yeah. Those rules are provincial in Canada, so different provinces have different rules. So this case, or this article, this is from the Toronto Star, notes, in a surprising turn of events, prosecutors have stayed a first-degree murder charge against a well-known underground Toronto rapper after a judge excluded key evidence allegedly linking him to a street gang, including music videos, social media posts, and portions of a YouTube interview. So, Hassan Ali, who performs as top 5, was about to stand trial in front of a jury for allegedly directing the murder of Hashim Hashi, a 20-year-old accounting student who was not involved in criminal activities. Hashi was returning home from dinner with friends just before 9 p.m. when he was fatally shot in his car while waiting to pull into the parking garage at 40 Falstaff Avenue near Jane Street and Highway 401. So, the Crown basically said it became clear crucial evidence has been excluded, and they stayed the proceedings. But how do we get there? Well, in this case, they wanted to tender evidence from social media, and they wanted to tender evidence from music. And the problem is that music ends up being a really problematic source of evidence. For example, let us consider Johnny Cash. Johnny Cash is not getting charged with anything because he's dead. It is very hard to lay charges against a man who is dead. But Johnny Cash has a song that goes, "Shot a man in Reno just to watch him die." And pardon my singing or crude facsimile of singing. Well, what if somebody in Reno had been shot, right? And what if somebody had witnessed a shooting in Reno where somebody got shot and the person sort of hung around to see them die and then left? Well, does that mean shit? I don't think anybody thinks Johnny Cash actually murdered anybody. The problem is that with certain kinds of music, the government decides that people are really murdery. But with other kinds of music, they're like, not so much. So, like, country music involves a lot of murders. A lot of murders, right? A lot of murders. There's a ton of things with, music with murders. Shot a man in Reno just to watch him die. Is, I shot the sheriff, but I didn't shoot no deputy. Like all the songs, right? And the thing is if you take these songs out of context, then they can sound real bad, right? So in this case, the judge acknowledged that while the evidence shows that he goads and threatens and celebrates the death of gang members based on where Hashi was killed, the probative value of the evidence is outweighed by the prejudicial effect. Probative versus prejudice. Probative versus prejudice. So, what does that mean? It is the universal rule of evidence. It is the rule of evidence from which all other rules of evidence arguably flow, but it is the fundamental thing. And what it means is that the evidence needs to be better at getting you to good answers than it needs to be at getting you to other answers, right? Because sometimes you've got evidence that is actually really, really shitty evidence, but is super persuasive. As an example, let's say I could tell a jury that this guy has committed 7 other murders. You better believe I could get him convicted on that 8th murder, even though I might have no evidence that connects the person to that 8th murder. Right? There's just nothing that might connect them to that 8th murder. But a jury would absolutely convict after having heard about the 7 previous murders. They'd be like, well, he has to have committed this other murder. Right? So I really hate the use of music and music lyrics as evidence, because I think that they should be presumptively inadmissible. And only if it's like super connected should it actually be that that it becomes admissible, right? Because there's certain genres of music. What is the Mexican slash South American genre of music that basically celebrates the achievements of drug gangsters? Like, that stuff is about crime all the time, but it doesn't mean that the musicians are, oh yes, narco corrida. That doesn't mean that those people are actually committing the crimes. It just means that they're talking about the crimes, right? So, are we going to start convincing those or convicting those people for singing about it? Now, here's where we get into some really interesting things. The Crown's theory is that Ali is a member of a street gang called the Go Get 'em Gang, or GGG. And he says that GGG refers to his record label, which the Crown acknowledges is a record label. He acknowledges that there's a record label called GGG, but says it's also a street gang. Okay, Crown is not doing super well right now. Yeah, there are some other issues on this, right? They intended to rely on some of Ali's rap videos and social media posts to prove his gang membership. Okay, just because somebody sings, they might be pretending to be in a gang, and they might not actually be in a gang, right? Now, they've got some further things here. One of the posts that played a significant role in the Crown's theory was a repost of a video stomping on a Shoppers Drug Mart bag, which was believed to be a grave display of disrespect towards Ali's brother, who was shot dead in 2017. I can tell you, I don't understand gang shit at all if this is the disrespect, but okay. Okay, fair enough. Like, this is, yeah. So they say this video was the impetus for the murder. Can you imagine you're on the jury and what you're hearing is that this murder went down because somebody stomped on a Shoppers Drug Mart bag? Okay. And then the judge has a key note here. There's no evidence that Mr. Ali saw this post or that he was a follower of the Instagram account where it was posted. Like, their whole theory is, hey, this guy, like, this thing was what set it off. And it's like, did he watch it though? Was he there? Yeah. Defense talked about the drill music genre, and they said that success often depends on the extent to which they're viewed as authentic, leading some to exaggerate their gang affiliations and involvement in violent activity. I.e., maybe he's just full of shit. Okay. The judge noted, while I would not go so far as to describe the Crown's case as weak, it is not strong. I just want to note, the judge is probably being kind when they say, well, I would not go so far as to describe it as weak. Because when they say that the Crown's case is not strong, keep in mind, the Crown has to prove things beyond a reasonable doubt. If it's not a strong case, it shouldn't be brought. So, yeah. It's this is going to be an interesting one. Right now, the full written decision is not out there yet. Right? It's not out there yet. But he noted that he was not the first judge to have to deal with distinguishing fact from fiction in forms of artistic expression in the specific context of rap music. Rather, the Crown seeks to introduce them to establish that the GGG is a criminal gang, that Mr. Ali is a member of it, and that the gang has a rivalry with the Falstaff Marquis gang. But they were allowed to play an intercepted jailhouse call that the prosecution says is an admission to his involvement in the murder. And that the quote there is, "Larry out of the car, take his life." Okay. So, other interesting elements of this. He was arrested in February 2021 and charged with being an accessory after the fact to murder. And he was released on bail. He got bail with house arrest and an ankle monitor. And then what does he do? Well, he learns that they're upgrading his charges to first-degree murder. And he flees the country. He fled to the U.S. And how'd that work out for him? Well, he was arrested in L.A., and then he was sent back to Canada. And Julia is asking a question here. Wait, had it proceeded to trial? Did it not? No, it didn't. They excluded the evidence of his music and his social media. That was kept out of trial. So that was kept out of trial. And because it was kept out, the prosecution stayed the charges. They killed the charges. They ended the prosecution because they're like, well, we don't have this key evidence that we needed, so we're not going to go ahead. And the thing is, if they're not going to go ahead without his Instagram post, then it was probably a pretty shitty case in the beginning, right? All right. So they note when the prosecutor enters a stay of proceedings, the Crown has up to a year to restart the proceedings under the criminal code. Yes and no. They actually have basically longer than that in theory, but here's the other thing. They're unlikely to restart his charges unless they get new evidence. And what kind of thing might be new evidence? What kind of thing might be new evidence in this case? Well, I can tell you what could be new evidence. If he starts making more songs, that like talk about that talk about this, then it could theoretically end up being used as evidence. And then the prosecution could be like, well, we're restarting it because now we've got new songs to argue our evidence. So, yeah, it's a whole big thing. All right. Megan says, should be a parcel from Australia at the P.O. box. Oh, fuck. I was at the post office and I forgot to check my mail. Alfligan says, don't you guys have free speech or something? Here's the thing. We have free speech, but they also could use your speech against you. So, yeah. Matilda says, hello from the Netherlands, 5:45 a.m. Hello. All right. I think I'm going to wrap things up unless there's some big questions here. We've been going for 3.14 hours, pi hours, which I feel like is, or 3 hours and 14 minutes. So we got pi up on the board there, which I feel like is sort of a good amount of time. I think you guys are I feel like you guys are winding down too. Chet asks, Are you an elf? Yes, I am an elf. I am trying to get the hot sauce running for sale. I'm trying to get it for sale. Hopefully soon I'll be able to sell this to you guys and get it out of my house. But we don't know. I have to fight with Shopify to see if I can get that moving, and if I can, so here's how it's going to be. The URL is, I'll just post the URL because it is what it is, right? But I'm also the initial thing is going to be that the initial price is going to be stupid. The initial price is $100 a bottle. The reason why is because you don't buy it at $100 a bottle. Don't buy it. I'm going to put discount codes for everyone who's a member or a Patreon or a Locals member. There's going to be discount codes. Those discount codes will be for 75% off. So that takes the price down to a much more reasonable level. That's kind of the idea there. So now, I mean, I guess if somebody buys it at 100, I can't stop you. But it will be going down from the 100 down to 25 later. So assuming that it doesn't sell out, right? Because if it sells out, then it's sold out. If it sells out, I'm going to get additional stuff made, right? I'm hoping the next round, I am very much hoping I can work out FDA, an FDA kitchen number so that I can send it to the US. I saw a request for, can I send it to Australia? I will have to figure that out. I don't have an answer for you, and I don't think I'll have an answer for you for this batch. The other thing, somebody says, am I wearing a hairband? No, I have earbuds, but I don't have a hairband. I've got, yeah. The other thing is that I'm working on another hot sauce. I actually just delivered a sample of this other hot sauce to my what do you call it? My fermentation guy. And I haven't heard his opinion yet. I want to get his take on it. I'm going to ask him for his thoughts. But I think it's really good. I think it's really something amazing. And if he agrees, hopefully there will be 3 hot sauces for sale soon. The next one is lime based, and so it'll be a I'm planning on calling it Lime and Punishment, which was somebody in the Discord came up with it, and I was like, I'm not going to beat that. Lime and Punishment. Now, Against the Tide says, Ian should purchase a new office chair with the profit. I am not expecting to make any money on this round. I'm just not. And the reason why I'm not expecting to make any money on this one is that it was a starter thing. There was a lot of startup sort of costs and figuring things out. A bunch of that like sort of tanked money that, might have otherwise I wasn't really expecting to have a huge profit margin in the first place, but I got to buy stuff, and I had to do things like I bought a bunch of boxes to try to ship bottles in. They're not big enough. They don't work. They looked like they would work, but they're not able to ship the hot sauce. So, I that was just money that is like, in the bin. I had to bite some additional, or I had to bite the cost of some. I lost some of my stickers for it, so that money is gone. It's just I got to figure all of this out. Like those labels are somewhere there, so it is what it is. IS is any clue how far Edmonton is from Seattle? It is about a 20-hour drive. So it's a ways. Julia says, did you not go to local packing store? I went. I thought I was clever. I thought I found a good bottle. Abriana Miller says, how much sugar in the sauce? Not a lot. This one here, I don't know about the other one. Sugars. How much sugar? Sugar. Carbohydrates, 0 grams. Sugars, 0 grams. So if you're wondering how much sugar is in this sauce, 0 grams of sugar. So yeah. I can read you the 0.1 grams of fat, 0.1 grams of protein, 20 milligrams of sodium, 10 milligrams of potassium, and 3.5 milligrams of vitamin C. 0 milligrams of anything else. So there's not a lot of What's the serving size? 1 teaspoon. 1 teaspoon is the serving size. And I can tell you, if you put a teaspoon of this stuff on like a fried egg, it'll have some oomph to it. So yeah, it definitely has some oomph. So all right. Someone says the hot sauce is colored water. It is not colored water. Ingredients. I can read you the ingredients. Fermented habaneros is the top ingredient on this. Number 1 ingredient, fermented habaneros. Apple cider vinegar, Thai chilies, shallots, Alberta red peppers, garlic, red Fresno chili, gray salt, chive blossoms, Carolina Reaper, Boot Jalakia, and Trinidad scorpion. So most of the ingredients are peppers, and yeah. Annabelle Feinstein. So if I flew into Edmonton for the day, can we meet for lunch so I could purchase some in person? Maybe. Maybe. All right. The pronunciation of habanero, though, I am very white. So at some point, I'm planning on doing a like a meetup. But I'm kind of waiting for fewer people to want to kill me. So, yeah. But I will arrange a meetup for that. Trinidad scorpion is a pepper. Trinidad scorpion is a pepper. It's not like actual scorpions. There's not like actual scorpions in here. So, all right. So I'm going to wrap this up, and we will, I'll see you guys next week, I guess. Oh, do I have something else here? Oh, yeah, we read this one. All right. So unless anyone's got any last minute questions or last minute things they need to say, I will wrap up here and see you guys soon. All right. Link. I don't have a link yet. Soon. I got to test it. I got to do a test order first. All right. Good night, everyone.